Okay, go ahead and get started. Hello, welcome. Welcome back for folks that are back with us tuning in. We're excited to have you all with us today. We're covering one of our special issues in this year's webinar series. Today is all about Title IX and restorative justice implementation in the criminal legal system. My name is Avery Arrington. I use she and her pronouns, and I'm one of the assistant directors at the National Center on Restorative Justice. Before I turn things over today to our presenters, I would like to thank our grant host institution, Vermont Law and Graduate School, our additional partners at the University of San Diego and the University of Vermont, as well as our federal funding partners at the Bureau of Justice Assistance, who are a part of the United States Office of Justice programs, as we all continue to collaborate in our efforts of supporting and educating the next generation of justice leaders. Today's discussion delves into Title IX, focusing on how changes in legal frameworks and policies intersect with and influence criminal legal and other systems. Our presenters today will detail and address the important efforts necessary to advance practices that encourage accountability and healing related to sexual harm and sexual misconduct. If there's questions that come up today, please utilize the Q&A feature, as we'll leave time at the end for those inquiries. But without further ado, I'd like to welcome Paige Duggins-Clay and Jay Wilgus, two amazing legal scholars and educators. I will let them introduce themselves as they talk about their work today, but thank you both for taking the time, and I'll turn it over to you.
Thanks so much, Avery, and to all the fantastic sponsors, fiscal and thought leadership across the country. And hello to all of you. We're sad that we can't see you and interact with you, but really, really excited and honored that you're joining us today for this really important and timely conversation. I was laughing because the first slide that the center put together has me and Jay's pictures, and we were so much younger. And here's another one. It's so nice to connect. I am Paige. I use she, her pronouns. I am first and foremost a parent of 4 awesome kiddos. You can see 2 out of the 4 of them there when we were hiking in Colorado recently. And I'll turn it to Jay to say hello as well.
Great. Thanks, Paige. And yes, thank you all for joining us. We're excited about this conversation to talk about some very important topics in an evolving field amidst a shifting legal landscape. And so, yeah, I'm Jay Wilgus. I'm an attorney and mediator by training and spent the first part of my career working in student affairs as assistant dean of students at the University of Utah, and then as director of the Office of Student Conflict Resolution at the University of Michigan, and now operate with Paige and others a specialized law consulting and dispute resolution practice called Clancy Street that focuses on helping parties find common ground. And we provide, in collaboration with the Center for Restorative Justice at the University of San Diego, external facilitation services, including informal resolution processes to campuses around the country who are looking for help. And so I'm very excited to be talking about a thread of that work with you today, and in great company with Paige to do it.
Definitely. And I wanted Jay to make sure introduce the broader collaboration and framework that we work within. And I'm happy to share that, for me, my journey to this topic has been really, deeply personal, from working on advising institutions of higher education on Title IX matters in all sorts of contexts, including in policy and practice, in litigation and defending Title IX lawsuits, to working pro bono on behalf of both individuals accused of sexual misconduct and survivors of sexual misconduct and sexual violence. And so have really seen this issue as an attorney up front, up close and personal, and from a variety of lenses. And I'm really grateful for this framework of restorative justice and for the broader community of all of you all in the various system roles that you play, either institutional, in the criminal legal, as an advocate in the community, or as a directly impacted person. And glad that we can have this space to unpack this really important and timely topic. Here's what we're going to try to work through in the next 90 minutes or so, with some time for questions. Because we have such a diverse audience, we're going to do some basics. We're going to talk at a high level about what is restorative justice and what are the basic restorative justice principles. We know we've got some folks who are various system actors who may not have as much familiarity with restorative practices as others. So we'll cover that. We'll then shift, and on the other end of the spectrum, we'll talk about Title IX and the basics and include a discussion of the shifting legal landscape, which includes some changes both in the regulatory context and then also in the litigation context. So we'll try to hit on those basics. We'll look at how Title IX systems intersect with criminal legal systems. That does overlap. And so though this is a very Title IX RJ focused session, we want to make sure and flag where system actors might be involved or might want to have more context. And finally, we'll work through a real life hypothetical to really work on identifying best practices that, as Avery alluded to at the beginning, promote healing and accountability. So let's jump right in. What is restorative justice? You can ask 100 different restorative justice practitioners what their definition is, and you'll probably get 100 very excellent answers. So here's the one that I love to work with, and I'll invite Jay to share his as well. This is the definition from Fania Davis, who is an attorney. You all, many of you may know Fania Davis, or you may know her, I think, more well-known sister, Angela Davis. Fania is a fantastic advocate, attorney, and spent a long time doing traditional legal work representing folks in various civil rights issues, and talks a lot about her own practice and how she really arrived at restorative practices as a way of doing healing and accountability work that was different and ultimately more effective than her traditional legal practice. And so I really connect with that experience as an attorney myself. And here's her definition: that RJ is about being profoundly relational, emphasizing bringing people together, and everyone who's impacted by wrongdoing to not just punish, right, but to address the needs and responsibilities, and to really create a space for harm to be healed. Not only the two individuals directly impacted, but to the community to the degree that that is possible. And so I really connect with this definition. Jay, I'll turn it to you. Is there anything here missing here, or anything that you'd like to add?
Not necessarily, just echo what you said. I think there's so many different approaches to it, and how we define it does matter, but what's really sort of the overarching sort of principles that we've got listed as 5 R's that really help define sort of what RJ is in its, in its most pure form, recognizing that it can take lots of different forms that we will talk about in greater detail.
Absolutely. And Jay, preview for us, we often think about RJ in terms of the 5 R's because we love alliteration: relationships, respect, responsibility, repair, and reintegration. So let's talk about those 5 R's and those 5 principles. First, RJ, as we alluded to in that definition, is deeply relational. Here's a picture of Desmond Tutu, who has obviously a deep connection to restorative practices in South Africa. And here's him talking about the relational dynamic of restorative justice, and describing the principle of Ubuntu, right? That the idea that I am because you are, our common humanity, that at our core as individuals, as human beings, that we are not just ourselves, in the world, that we are in community with one another, and that the actions that we have impacts on one another. And so I really connected with this because I first learned about restorative justice principles when I was a very young undergraduate student living and studying abroad and working in South Africa. And so I really connect with that. And really focusing on this idea that so many of our traditional legal and criminal justice systems for responding to harm in our communities and in our lives really focus on this, punishment, this carceral system, without doing any work, right, to address what can be a really meaningful component of this, the interpersonal dynamic. And that we really want to make sure that even if we're having accountability in a variety of frameworks, that we're really focusing on healing the deep relationships that connect us to one another. Jay, would you add anything to that?
No.
All right, let's go to the next R.
I think what you said, though, about sort of the importance of relationships and community is directly relevant to the second prong, though, as when we think about respect. And one of that that has to do in 2 ways. When we think of sort of my colleagues and the sort of who are more closely involved with the criminal legal sphere, we know that it can be a misnomer to talk about pressing charges and the prosecutorial discretion that exists, and the way in which victims have or don't have a formal role in the process. And so RJ is really intended to not only elevate the experience and role of those who have been harmed and respect for their rights and their voices and their wishes and autonomy, but also to respect the humanity of the individual or individuals who have caused harm, recognizing that we cannot simply address and repair harm if in the course of the process we are inflicting more harm, and without recognition that those who have caused harm often have been harmed themselves. And we have RJ allows us to look at that entire picture with respect for all, as indicated on this slide.
Thanks, Jay. Third R is repair, right? RJ focuses on repairing harm, and we always get these questions, how is RJ different than your traditional process? And so we hope this graphic helps illustrate that. When you think about your traditional process, and I think this is true for both civil legal processes, student conduct processes, which is where we most often talk about Title IX, right? But even in our criminal justice system and process, right? There's a real focus on identifying what was the rule or law that was violated, right? Give me the citation. Once we identify that, figuring out, is there enough evidence to support that finding of responsibility, a finding of guilt or innocence, meeting those evidentiary standards, right? And there's all sorts of dynamics that come into play in doing that process. And then assuming that we do have a finding of responsibility or guilt, asking, how do we punish that person? What's the legally mandated or appropriate sanction based on, a particular framework, either a sentencing framework or maybe sentencing guidelines or school policy. And then increasingly, right, particularly for our partners in higher education, there's increased scrutiny on the systems that produce outcomes in all sorts of cases, but including and especially sexual misconduct cases. Did we follow our institutional policy or procedure, or if you're a system actor, did we follow the law, right? Is there a reason that this is going to get appealed or overturned? And that's where so much of the emphasis is on our traditional process. In a restorative justice framework, the questions we ask and the focus is very different. Rather than asking what rule was violated, we ask the question, what is the harm? And we'll unpack in a couple of later in our session, what is harm and how do we define it? Instead of focusing on the evidence and this procedural piece, we really ask the question, who's responsible for that harm? And responsibility, as Jay alluded to, obviously there's is almost always, and especially in cases of sexual harm, an offender, right? A person who is accused of violating the policy. But there may be other actors who are responsible for or contributed to what happened. And restorative justice holds space for those sorts of questions, dialogue, and accountability. It then asks, what can the persons who are responsible do to repair it? And that looks very different than a framework of punishment and punitive nature. We'll unpack what potential remedies can look like in this framework. And critically, and this is where our traditional systems have very little formal framework, it asks, how can we rebuild trust? And going to the point that Jay made about having respect for and all individuals, including an individual who engages in problematic behavior, we want to find ways to bring them back into the community and cultivate trust between the two individuals impacted, but also between the individual accused and the broader community.
So on the matter of responsibility, and in cases of sexual harm, I've been working on this, in and around this to advance RJ applications to sexual harm for just about 20 years now, both inside and outside the campus context. And one of the pushbacks I have heard all along is that folks will never accept responsibility for sexual harm. It won't happen. There's too much legal risk. The risk of criminal prosecution is too great. The risk of civil liability is too great. Folks won't do it. I'm here to tell you that's not true. And folks are willing to accept responsibility. And we'll show a case study later that's publicly available that demonstrates that. But what we mean to do in creating these spaces, in my mind, is to create processes that invite, encourage, and incentivize truth-telling. So much of our adversarial process discourages truth-telling. It does not invite folks to say, yep, I did it. And so the spaces we create in an RJ process are intended to make room for that self-implication. So when folks are engaged in an adversarial process, or frequently we can sort of point fingers on the front side. And our work is about helping folks sort of direct that finger inward to say, how did I contribute to this harm? What can I take responsibility for? And that looks very different. Sometimes folks are willing to accept responsibility for a policy violation. Sometimes they're willing to accept responsibility for having caused harm or for having engaged in particular types of behavior. And so that's really important as we think about that. If you go to the next slide page on reintegration, it's also really important to think about what outcomes we're hoping for. In the campus context, the greatest sort of outcome that can be levied, or most extensive, is sort of exclusion from the campus community, right? It looks like suspension or expulsion. And when we're talking with campuses, we like to make evident that that is very successful in doing one thing: preventing the student from enrolling in classes at that institution again. But it doesn't mean they can't live in Ann Arbor. It doesn't mean they can't transfer to the next institution where they might be at. It doesn't mean they can't, still attend off-campus events. And without a no trespass order, doesn't mean they can't be on campus. And so we shouldn't mistake exclusion with efficacy. And that applies in the criminal sphere as well, when we may make the reasonable choice to have a person incarcerated for a period of time or to exclude someone. We should never mistake that with the with an outcome that has the likelihood of reducing one's propensity to reengage in that behavior in the future. And so we approach this work with a big community in mind, recognizing that these folks are going to be in community somewhere at some point in time, and we have a responsibility to help reintegrate them in the most effective fashion possible. And that often means providing appropriate support and accountability along the way.
Thanks, Jay, for tag teaming those 5 R's of restorative justice with me. We're closing out, coming to the close of our RJ overview section, and we just always want to be sure to take a moment and honor RJ's roots, which are Indigenous first and foremost. And so just highlighting and paying homage to the many Indigenous communities and cultures that have used RJ for generations, including and also provide a useful framework for those of you who are new to RJ and wanting to connect to other traditions that have been using it. Lots of folks are probably familiar with Nelson Mandela there. I showed you Desmond Tutu earlier and the concept of Ubuntu, but Truth and Reconciliation Commission happening in South Africa is a common way for folks to make that connection. Oh, that's restorative justice. That's one powerful framework that has come out of South Africa in addition to other places. You see there in the bottom right, the Honorable Judge Robert Yazzie, who's a Navajo peacemaker and leader who's really credited widely for incorporating Navajo healing principles into their justice system and dynamic. Great research and lessons to be learned there here in North America. On the bottom there, you can see the Maori tradition of family group conferencing, which is at the root of a lot of the traditions we see in restorative practices today in education. Many of us using those restorative justice conferences as an alternative to exclusionary discipline practices. A lot of those really are rooted in a whole host of restorative principles, but that family conferencing model really growing there. And then, of course, Howard Zehr, incredible American thinker and scholar, which is particularly relevant, I think, for this context in this conversation today, who's credited widely for bringing restorative justice into the main, I think is one way of saying it here in America, and really doing work around victim offender dialogues and bringing restorative principles into the criminal justice system. So these are all great thinkers. There are many, many others. And a great community of current contemporary practitioners who are leading the way and contributing through all sorts of cultural and faith traditions. So just always want to take a pause to recognize that. How are we doing, Jay? Ready to go to the next section? All right, so now we're going to shift a little bit and talk a little bit about Title IX. And there's days and days of trainings that we could give you on Title IX, but that's not what we're here today. We just want to give you enough to where if you are not a person deeply steeped in Title IX or working at an institution, that you have enough context to understand how restorative justice can serve as a method of resolving and addressing harm in the context of campus-based sexual misconduct. So let's dig into it. I know there's lots of potential questions around this, and we'll try to get to them at the end as well. First of all, Title IX, I'm a lawyer and there's lots of folks who spend all sorts of time working on laws that are pages and pages and pages long, right? Title IX is really simple. I think it's 32 words, very straightforward. No person in the United States shall be on the basis of sex, and that's the critical language, right? On the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So that's the law of Title IX. Of course, it's never that simple, and has since become the subject of much scrutiny, debate, conversation, and regulation, which will be the focus of our conversation in just a moment. But here it is in a nutshell. Let me tell you 5 things about Title IX that are just at a high level you need to know. First of all, one of the most important features of Title IX is that it requires every school to designate a Title IX coordinator, right? A person who is responsible for overseeing and coordinating all of an institution's responsibilities and functions with regard to Title IX. Of course, those responsibilities can be shared and delegated, but ultimately there has to be at least one person who's designated and has that ultimate authority and responsibility on behalf of the institution. Schools at their relevant to this context, at its core, Title IX is about preventing and responding to discrimination and sexual harassment, right? So we got to prevent it. And when it happens, we have to work to prevent it. And when it happens, we have to respond appropriately. Schools have to post notice of policies and of Title IX policies and procedures. There are other sort of areas of both state and federal law, right, that intersect. And so when we put out our policies and procedures, we have to account for the broader framework of sexual misconduct and sexual assault related laws that might impact our response to sexual misconduct. When we are responding and engaging in efforts to address sexual misconduct, we have to be prompt as school leaders, right? We can't sit on these cases. We have to act quickly to address safety and harm related issues. We have to be equitable, and we have to make sure that we're treating everybody with the dignity and respect that we were just talking about in our restorative justice overview. And they have to be appropriate, right? They have to be appropriate. And by that, we mean they have to be tailored to address the harm that was caused and to prevent it from recurring, right? So that is really what schools are aiming to do. And finally, there can be a lot of confusion about Title IX because there is litigation, and we'll talk about that. But Title IX is enforced by the U.S. Department of Education, the Office for Civil Rights. And that creates a really unique opportunity, right, for the department to be in dialogue with schools and with advocates and with those impacted to learn about the experience and to produce guidance, right, in order to shape institutional responses to sexual misconduct. And so rather than there being a criminal law enforcement response or a civil litigation responsibility, compliance with Title IX is really overseen by the Department of Education, and we'll see that become a predominating feature in our current landscape. And Jay, feel free to jump in if you have anything to add. So just quickly, again, we're talking about the law of Title IX and that it really only applies to entities that receive federal financial assistance. So that includes schools, but it could include a whole host of other entities that receive any kind of federal financial aid, right? Head Start programs are a great example of that. And so there's a whole wonderful manual that talks about whether you might be subject to a variety of federal civil rights protections because you receive federal funding in some way, but it's definitely schools. The nuance of Title IX is that it doesn't apply to an individual person, right? The law of Title IX doesn't necessarily apply directly to someone who is an employee or a student at a school, but rather it regulates institutions who are then responsible for regulating the behavior of their students, right? So when we're talking about the law of Title IX, we're really talking about the institutional responsibility. And that's different, right, than the other impacted individuals when sexual harm occurs. It's different than filing a civil lawsuit against an individual or a local law enforcement agency initiating a criminal proceeding, a criminal prosecution against an individual. We're really talking about institutional responsibility. Of course, though, through that framework, schools do regulate students and their communities based on the principles and the legal obligations they have under a Title IX framework.
I might just add, Paige, to make the connection even more explicit for those not as familiar. You know, it's so important we talk about this because what we can do with, in terms of informal resolution processes or restorative justice, is governed now strictly by these regulations. And so understanding this context for those practitioners who are outside the university sphere may be sort of like, why are we talking about this? But it's really important if you want to do this work to understand this context in terms of what is possible in this space in the educational context, whether it's post-secondary, secondary, or primary school.
Absolutely. And I'm glad that you brought that in. I mean, I showed you the text of Title IX and we talked about the basic compliance pieces, but there really is now a very robust and evolving set of laws that impact how schools have to must and how they can, to Jay's point, respond to sexual misconduct, including sexual assault. Probably the biggest area of authority, of legal authority, are the regulations that we've been alluding to. And we'll talk a little bit of history here, but that regulatory framework really provides sort of the first foundational question of how schools are going to be implementing and complying with Title IX. So we'll, in the balance of our time for this section, talk about what those regulations are, how they've evolved, and how, as Jay pointed out, they make room for and permit, and also in some places limit, our ability to offer restorative justice responses to sexual misconduct. And those are regs that are published right in the Code of Federal Regulation. They go through a robust vetting process and are worked by the department's professional staff and legal team to put those out into the world. And so that is one area. And just so that everyone is on the same page on this, there are other areas, right? Of course, the department can put out guidance that can be very helpful for practitioners. Those are, in the education context, frequently known as Dear Colleague letters. We might also see question and answers, Q&As, right? Those are really helpful and useful guidance documents that schools can and should refer to in compliance. Similarly, there is a separate area of, again, evolving case law that is about how Title IX is interpreted and applied in the individual liability context. So when a student sues a school for a civil violation of Title IX. So there is a whole host of case law around that. That's not really the subject of our conversation today, but just flagging that it's out there and is often referred to as a useful reference point in terms of how to comply with this law. Of course, schools are required by law and as good practice to have their own policies, which must comply with federal law and can also go beyond federal law in terms of the protections that they offer, the practices that they engage in, so long as there's not a conflict. And finally, I put this in asterisks, state law increasingly is regulating how schools must respond to sexual misconduct on their campuses. I'm calling in today from the state of Texas, in which there have been really landmark changes in how schools respond to, document, and punish folks involved in sexual misconduct matters. And that also may be true in the jurisdiction that you're hailing from. So that's also something that we want to be tracking very carefully. So I have a former colleague when I was an associate at a law firm called Hush Blackwell, where I did a lot of my practice as a Title IX attorney. And so my colleague Scott Schneider, who now has his own firm, he's grateful for the free advertising here. He has this great history of Title IX, has really studied it, and is a national expert, and talks about there being 52 years of Title IX history in 5 minutes or less. So I wanted to give him credit for coming up with this content, and I'll do my best to hit these points quickly. But again, this context I think is useful in a time where the pendulum continues swinging in terms of how schools are being asked to enforce and comply with Title IX. So let me just give you a little bit more context. First, Title IX passed in 1972. It was modeled after another really important and deeply interconnected federal civil rights statute, and that's Title VI, which protects individuals on the basis of race, ethnicity, and color. And at the time when it was passed, it was really focused on gender discrimination in admissions and in hiring. We wanted more women on campus and more women moving into tenure track, right? Professorships and leadership roles. It was very quiet. I always joke, it was signed by President Nixon. And, I don't know that he was, legacy is well known for being a champion of women's rights, but he signed Title IX. And so I always like to reference that. This was a law that was not controversial, that was about creating this baseline fairness and a foundation, right, that has since grown into creating a lot of really important protections. The biggest immediate backlash was in athletics. So my alma mater, the University of Texas, and several other big-time football programs immediately sued the department to get these rules tossed out because they were unhappy with how it was impacting the funding for certain sports. That litigation was ultimately unsuccessful. And I think if you ask any actor, historically, enforcement of Title IX was pretty lackluster. I mean, for years and years and years, there was very little formal agency action other than there was an initial wave of regulations issued. And I think for over 30 years, there were not, maybe 40 years, there were not regulations issued again. At one point in time, I always offer as a reference point, Clarence Thomas, who's now just on the United States Supreme Court, was the director of the Health, Education, and Welfare Agency, which preceded the U.S. Department of Education and was responsible for enforcing Title IX. And so just to sort of give folks a sense of where we are in the timeline of this really important law. And that really, the tempo of that and the increase in enforcement really came in 2011 under the Obama administration with what is now known as the landmark Dear Colleague letter and associated question and answer guidance issued in 2014. And that was really the first time in the department's history, though there had been other guidance and there had been efforts to try to work on this, where there was a really robust enforcement in terms of student-on-student, peer-to-peer sexual harassment, really catapulting us into the era we're in now, where we're seeing a lot of policy debates about what is the role of a school in educating young people and the college community about sexual misconduct, preventing it, and responding appropriately when it occurs in the context of an educational program or activity. Jay, would you add anything to that? Did I hit 5 minutes or less? I hope so.
I think less. I think the piece that I might add in here, just to again expand our thinking about this, that when we're talking about sort of Title IX and RJ applications to sexual harm, really want to draw our attention to like a broad spectrum of behavior that it is governed by these policies, and those behaviors can be what we might generalize as non-contact based offenses that are verbal, sort of sexual harassment, voyeurism, those sorts of pieces, to contact-based offenses. And there's an important distinction for our sort of colleagues in the audience who are, operate in the criminal legal system, that some of this behavior is criminal in nature, some of it is not. And so when folks are responding to Title IX matters on campus, it's really important to keep that broad spectrum in mind, to recognize that there's a subset of behavior that's just not criminal in nature, even if folks admit to it, that wouldn't subject them to criminal liability. And so, yeah, I just wanted to add that piece here, Paige.
No, I think that's so helpful and important that though the topic, the focus, and I think the a focus of advocacy and awareness and of media, right, is really around this problem, a really serious problem of sexual assault that's connected to a college campus, that absolutely there's a whole host of behavior, problematic behavior that is regulated by Title IX, and that schools have to spend just as much time working on addressing. So that's super helpful context. So just again, to come back to our current context and where we are, and again, flagging for the various system actors that we have in our audience today. I mentioned to you that, regulations tend to be, in this day and age, the driving force behind the framework that schools operate under in terms of compliance and enforcement. And of course, I mentioned the robust sort of regulatory process the department will go through, and that they are different standards, right? I want to be really, really clear, because if you are in a different legal system or different legal context, a different set of rules may apply. So this is about when the Department of Education is looking at institution's compliance for the purpose of federal funding. That's totally different than in a civil lawsuit or in a criminal justice context. So really these regs set those standards for administrative enforcement. Don't alter the standards set by the courts that we mentioned previously. For those of you out in the audience wondering, what is it that happens if there is a violation of Title IX? The main enforcement mechanism that the department has at its disposal is the ability to withhold federal funding. And so that is the real leverage that the department and that advocates really lean in on when it comes to ensuring that schools follow their obligations. If they are found out of compliance and do not take steps to remedy those issues, they can be subjected to having their federal funding revoked. The revocation, I don't know if it has ever happened in the context of a Title IX. I'll have to research that, but it happens very rarely. And thankfully, through the administrative enforcement process, we most often see districts and colleges and universities reaching an agreement with the department to remedy the issue. So this was really a powerful tool. And you can look at the ways that the department is thinking about remedying violations. There's actually, they post a lot of the resolution agreements online. You can see how these things get addressed. And that can be a really, really productive way of seeking accountability. I also think it's important to flag, to Jay's really good point earlier, that there's different evidentiary standards, right? For our criminal justice system actors, you're operating under, for example, a legal evidence standard of, from various levels, but what is it? Beyond a reasonable doubt, right? And that's a really high standard by a jury of your peers or other standards, right? We as school actors are not necessarily operating under those standards. It tends to actually be a different standard, the preponderance of the evidence, which is a traditional in the civil legal context, or maybe sort of an intermediary standard of evidence called clear and convincing, right? Some school systems will use that standard. So just flagging that that's really driven by institutional policy. Schools have a lot of discretion to do that. But we think that's a really important thing to flag when you think about the intersection between Title IX and criminal legal systems. The last thing I'll just say about this is, again, there's other areas of law. There's Title VII, which governs sex discrimination and employment. And there is an overlap, right, between Title IX and Title VII. And so that's not the subject of our webinar today, but we're just flagging that there are other areas that we're not going in on that may bear on a school's process or decision-making in a particular case. So we're gonna rewind. I showed this image to my 6-year-old and she had no idea what it was because she'd never seen a VCR in her life, the little triangles and the rectangle there. We'll go back to 2020, hard year for so many of us at home and for many schools working to implement a brand new set of regulatory framework. And it was really, again, another sort of landmark moment in the law of Title IX in terms of having sort of a shifting framework. And so if you're going to hear a theme, I've mentioned the pendulum, right? Schools have really been caught in a little bit of limbo working to implement new regulations that have different frameworks, require different personnel and levels of training. And so we're really in this moment seeing a lot of schools grappling with how to come to terms with this evolving area of practice. I know we have a limited amount of time, so we can't go into all of the ins and outs of the 2020 regs. I actually have a binder. I printed them out along with the preamble at one point, and the binder is about this big. It's a great demonstrative in terms of the rules themselves and the guidance. But here are some high-level points that you should know. First, the 2020 regs really sort of contracted the legal definition of sexual harassment in an effort to limit the affirmative obligation of schools to respond to certain kinds of sexual misconduct. So it really focused on sexual misconduct occurring in the context of a school's education program or activity, and really attempting, I think, based on the language in the preamble, to not have schools be responsible for addressing, for example, conduct that occurred abroad, conduct that occurred off campus, even if that off-campus behavior impacted a student's access and experience in education. So that was a really big landmark change in those regulations, changing some of the standards, really ramping up the legalistic model of investigating and adjudicating sexual misconduct claims. So where we previously were seeing sort of one college administrator investigating and making a determination about responsibility for Title IX, we now are seeing these robust quasi-judicial systems, right, where we have an investigator or an investigative team, robust evidentiary requirements, and more voluminous records. I'm using the language of lawyers here. Tribunals made up of trained individuals. So you're seeing sort of these hearing panels, lawyers cross-examining folks, or advocates cross-examining witnesses, a very different feeling and setting, and one that many survivor advocacy groups criticized as being whatever the intent was, the impact being to really intimidate, overwhelm, and limit the feelings of trust and comfort in participating in that process. And we did see a marked drop in the number of complaints filed under this system. That live hearing and cross-examination in particular being a main driver of that. Jay, do you want to add anything to this high level?
No, I think that's good.
Okay.
Great.
I'll pass it to you to talk about how informal resolution has evolved.
Perfect. Stepping sort of, I guess, back and also deeper in at the same time. So Paige has done a great job sort of explaining the sort of history of Title IX and its application. And I want to zoom in now on sort of the principal focus of our time. And I know what some folks are interested in, which is, how does RJ apply? And we, in talking about this in a regulatory parlance, find ourselves sort of as a way of complying with the regulations, referring to these processes as informal resolution processes, because that is regulatory language. And so I'm going to talk about that for a few minutes as we also do some time adjustments page on our end, because I think we'll want to get caught up to our next section as we can. But when we think about those adjustments, Paige noted how there was really a lack of enforcement for a long period of time, not a lack of interest, but certainly a lack of enforcement. And that also resulted in a lack of clarity about what's possible. But when you're thinking about informal resolution now, it really is helpful to look back to 2011 and the April 4th, 2011 Dear Colleague letter, which had some pretty prohibiting or prescriptive language regarding informal resolution, and said in cases of involving allegations of sexual assault, mediation is not appropriate even on a voluntary basis. So for those of us who have been doing this work, that language felt cumbersome and inaccurate, because it seemed to roll into a restorative justice process and conflate mediation with restorative justice. And so in Paige, can you just click one? In 2014, some colleagues and I helped Mary Koss, who had run the Restore program with a set of criminal offenses on misdemeanor criminal sexual assault in Pima County, Arizona, and Karen Williamson, who's now at the University of Michigan, published a paper that we think helped outline all the ways in which an application of restorative justice could not only be compliant with the then existing regulations and guidance, but also enhance schools' ability to further meet those needs in ways that met not only victims' need, but party who's caused harm's needs and the institution needs. And from there, there's been greater interest. And so in 2016, there was a group formed called Campus Prism under the leadership of David Karp and others at the Center for Restorative Justice that took greater and greater interest in this. And the advantage of that interest is that I think we were persuasive in writing and other education and advocacy in helping the department and the broader field understand that informal resolution really should be thought of as broader than simply references to mediation. And so the 2020 regulations acknowledge that informal resolution can include various approaches to this, including restorative justice. And so we may not have time to address sort of the key distinction between mediation and restorative justice beyond here, but for present purposes, you should know that there's lots of different types of mediation. The most common is generally referred to as problem-solving facilitative mediation for folks who are in conflict with one another. It's not as though that is never appropriate, although there are some folks who take that position, including professional organizations. But our default is a restorative justice approach because it recognizes there is a party who's caused harm. That harm may in fact be a crime, and we have a responsibility to address that in a really trauma-informed, victim-centered way. And so I am personally grateful that those 2020 regs allowed us to expand and use RJ, and now find that our work is really needs to focus in on helping folks understand like where mediation and why not sometimes, and how can RJ be used as a practice. And so we're going to spend the bulk of the rest of our time on talking about sort of how RJ's application to these pieces. For purposes of like bringing us to current day, we have a set of rules that will come into place and take effect on August 1, 2024. And I think I just would summarize by saying they maintain that current structure, which recognizes that RJ, mediation, other forms of alternative dispute resolution processes may be used as an informal resolution process. And it simply provides a few carve-outs of when that's not appropriate. And that includes two instances when it involves an employee engaged in behavior against a student in a secondary, elementary school or a secondary setting, or when the process would conflict with federal, state, or local law. I appreciate that the current regulations also give us guidance, one more click page, to say that there may be some instances when the behavior is so severe or there's such a risk of harm to current participants or others that the Title IX coordinator may decide an informal resolution process is not appropriate. I'll tell you that my experience in working on a lot of these cases is that those cases, the ones we fear the most, the ones we calibrate toward, tend to be less common than those others that we can address successfully in an informal resolution process. So the new rules, in contrast to the old ones, have a lot of detail about how schools can go about executing an informal resolution process. And the folks who put these together for us were very thoughtful in that. The one piece I want to draw your attention to actually has to do with something that is not included on this slide. Now go back one page at item, there used to be one more forward, sorry. At 3, 7, and 8, that was excluded from the final regulation. So forward one now. It has to do with the confidentiality of these processes. And in the mediation environment, in civil settings, we like to talk about how mediation is confidential. Matters disclosed as a result in the course of a mediation process cannot be used in a civil setting. And that's because mediators in most states are afforded a privilege that precludes them from being called as witness and that protects their work product and discussions. one forward page, there was a similar note in the negotiated rulemaking process that would have included that similar language and afforded a level of privacy and confidentiality that was not included in the final rules. And so that is really important to note, that when you're thinking about an informal resolution process on a campus, we do have to think about confidentiality in a way that is contractually driven, is based on understanding of the parties, because our RJ facilitators, unless you're very creative, are not likely to be considered mediators who would be afforded a mediator privilege like those in the state of Maine might enjoy under Maine Rule of Evidence 514. And so I mention that because the privacy is important, and it's not statutorily or guaranteed by the regulations. It has to be designed as part of the process and coordinated in partnership with the parties, the Title IX coordinator, and other interested stakeholders. I think that's what we wanted to say, Paige, on that chunk.
Totally agree. And I really appreciate the confidentiality point, because to give you a spoiler, one of the number one areas of pushback or question that we always get is, how are we going to respond to concerns, reasonable concerns, right, of individuals, including and especially individuals accused of sexual misconduct that might rise to the level of a criminal violation, to participate in our institutional Title IX processes and a restorative justice process where they might be asked to make admissions that could subsequently implicate them in a criminal proceeding. And so understanding the legal boundaries established in the regulations, designing the process that, as Jay said, contractually sets the standard institutionally for how we want to contain those conversations and admissions so that we can hold that space is really, really important, and probably one of the most important design features if you're thinking about working on this. And we'll talk about how we can maybe do an MOU with local law enforcement as another tool for addressing that in the Q&A, and provide some resources around that. The last thing we'll say about the current, we'll ask two things, I guess, about the current context so we can move ahead, is that the new regulations were issued in April after extensive rulemaking. I put the image here. 240,085 comments received in that rulemaking process. I think that was a record. That certainly for Title IX, the department had to work hard to look through each and every one of those comments and respond in anticipation of litigation, which again is another spoiler alert, there is some. And really the 2024 final rule does some important things. It really restores that scope of Title IX, Title IX's jurisdiction, so that incidents that occur that have an impact on the educational environment and a school is obligated to respond to. So that could include off-campus incidents that nonetheless have an impact on a person's access to education and opportunity. It also has very explicit protections for members of the LGBTQ+ community, landmark guidance there, implementing Supreme Court guidance language in Bostock, and really, really, again, landmark, critically important protections, the results of great advocacy, strengthening protections for pregnant and parenting students who, of course, are, exist and have an identity connected to their sex and gender, and have very robust explicit protections under this current rule. All of that said, is we mentioned that this final rule is going into effect in August 1st of this year, just right around the corner, but only unfortunately for some communities. The last time I checked, I don't know, it seems like this is changing every day, but just last week that because of litigation that is ongoing in various jurisdictions, there are at least 15 states where the final rule is not going to be enforced. And so I've got the list there. There's a caveat, we have a but there, because one of the federal courts that's really driving the injunction that is covering these states has sort of left open the possibility that additional schools and states might be covered, so long as there's a member from one of these three organizations who are bringing this litigation have a member on a school's campus. And so that includes Young America's Foundation, BMO Athletes United, and Moms for Liberty, which share an ideological framework that is an opposite to the department's current framework. Many of these oppositions are around, no surprises here, the department's explicit protection of LGBTQ plus students and some other things that they're nitpicking on. So this is ongoing, and you've got to continue to check this context is currently evolving, and unfortunately is creating a patchwork of legal frameworks that schools are struggling to comply with. And so you always have to check on the context where you are. And the bottom line is, regardless of the regulatory framework, that's very important, but at the heart, Title IX is about protecting individuals from sex and gender discrimination, preventing it from happening, and when it happens, responding in a way that is equitable and that really meaningfully addresses harm. And that is why we advocate so strongly as restorative justice as a really important tool and framework for responding to Title IX matters. I'm going to skip the big picture because I want to try to get us back on track, but at a very high level, we're guessing that you're here because you're interested in restorative justice, or maybe you're practicing it, but you may need a little bit more guidance on the how. How does this work? Is it a robust, accountability-driven framework that can stand up to the really serious harm that occurs when sexual violence is involved and other related incidents are involved? And then sort of related to that, on the school side, we see more and more people coming to sessions like this to learn about RJ, because like me, right, as a attorney who was doing investigations and writing reports and serving as a hearing officer and then defending schools in litigation, so many of the folks who are involved on the school side are just burnt out on this investigation process that takes up so much time and resources. And regardless of the quality and the commitment to following through on these very legalistic adversarial proceedings, deep dissatisfaction institutionally, creating a lot of burnout for our Title IX and related professionals, and deep dissatisfaction for the stakeholders, for the directly impacted community members who are stuck with the outcomes of these decisions that don't account for the broader harm. Jay, did you want to take this slide? Or was it me? Sorry, I think it was me. Sorry. I'm trying to expedite our session a little bit, and so that's my bad for getting off of track. Just wanted to give another nod to our friend David Karp. Actually keep on my desk his and many other little books of restorative justice. So if you're curious about restorative justice and you want like a primer that's more than a 90-minute webinar, want to encourage you to check out this series. You'll see screenshots of some of these books at various moments. But in his book, our friend David, who runs the Center for the Restorative Justice, talks about how restorative justice really is this framework, right? That is about fulfilling the educational mission of institutions of higher education, and really talking about how we respond to harm in our community. Really says not only something about how we think about and are taking serious incidents that occur in our community, but also how we are respecting the autonomy and the educational potential of the young people in our community. Jay, what would you add to that?
I think that's exactly right. I think, the prior slide did it, and I'm thinking, Paige, that we might be able to skip through these next couple slides to get us up just by referencing, if I harken back to sort of 1976, there was a famous conference called the Conference on the Popular Causes of Dissatisfaction with the Administration of Justice. And suffice it to say that folks in the criminal sphere, folks on campus, have been dissatisfied with traditional approaches to sexual harm because it has not served victims' needs. It has not allowed those who have caused harm to take appropriate responsibility or treated them as human. And it's frustrated institutions, and it's frustrated institutions who have been looking for more options because adjudication and adversarial systems takes so much time. And so if you think about it from a time perspective, I like to say part of the reason we advocate for truth telling is because if someone who is reported as causing harm says, "I did it," we can eliminate the entire process of fact finding, all the back and forth of know this, not that. It largely resembles intensive pleadings now, and we can meet not only institutional needs, but victim needs and respondent needs in a way that creates greater efficiencies for our staff members and increases satisfaction in the long run. And so we could talk a lot more about how RJ is trauma informed, how it centers victim experiences, how it can save time. And want to also make sure we have time to discuss how this works over time, and provide an example and time for you to ask questions as well.
Absolutely. I just wanted to say a word about trauma because I know that that's important to many folks out there, especially our system actors. And we'll get into that when we work through the story the hypothetical that we'll share. But there's lots of great research and articles. And what we want to flag is that one of the crossover points where we look at how Title IX connects to and relates to the criminal justice system is that they share a commonality in that there is a huge disincentive, right, for individuals who are involved and accused of sexual misconduct to admit responsibility, to acknowledge causing harm, to Jay's really good point. And that's why we spend so much time and energy and resources and simultaneously create that traumatic experience for all involved, including and especially the survivor. And there's a lot of really great research and testimony coming out about how, certain individuals who are impacted by sexual violence, survivors often want an acknowledgement, right? They want that admission. They want to know that the person who hurt them understands what they did and that they're not going to do it again. That's the outcome that they want. That's certainly not every survivor or every advocate, right? There's a whole spectrum of needs, harms, needs, and obligations that occur in this context. But we hear that overwhelmingly in the data, anecdotally. And how are we really working to create systems that hold that space for survivors themselves to have their needs met and have that acknowledgement? So I just wanted to hit that really quickly. Yeah, and shift to talking about incorporating RJ into our practice. I'll say just really briefly, again, here's another plug, Restorative Justice for Campus Sexual Harms, really great new resource. So if you're looking for just a short resource on how to implement some of these, want to pitch that, and this great diagram to just emphasize the point that if you're thinking about restorative justice interventions to any kind of harm, but including sexual harm, it's really important to think about it not just as a program or as an intervention, but as a framework, a way of thinking and acting, and introducing restorative justice elements in various contexts that are not just necessarily always tied to an incident of harm. And so there's lots of modalities, there's lots of ways of incorporating restorative practices. We don't have time to talk about all of them. But for today, what we're really talking about, and one of the primary methods of restorative justice in college communities and in the Title IX context, is using a conference, a restorative justice conference, to address to respond to the harm. And so, Jay, I think I'll turn it to you to maybe hit on the main components of a conference and sort of lay that out as we move into talking about Amwin and Samir in our next couple of slides.
Perfect. So we mentioned it before, but worth noting again, part of our reaction to the regulatory terminology is that it could suggest that an RJ process is informal or less than or not as effective as in some ways. And that's just not true. RJ processes in this context it is critically important to prepare and to not only for the facilitator to prepare, but for the parties to prepare and for the parties to prepare with the facilitator. And so we're suspecting, again, this audience is sort of mixed in terms of awareness of RJ processes, but for purposes of this example, it's important to understand that an RJ process at a foundational level has a sort of pre-conferencing phase, a conferencing phase, and a post-conference phase. And that pre-conferencing phase is not only the point at which the institution or the individuals might reach out to a facilitator, but it's also the point at where a facilitator is sort of assessing readiness. Is the individual who's been reported as having caused harm interested in accepting responsibility? Are they there? Is the individual who experienced harm prepared to participate in a restorative process that emphasizes not only accountability, but ways to redress the harm? Or are they interested in a retributive, punitive process and having the individual expelled from school? Because if that's the case, then the RJ process isn't for them. Either way, the process must be voluntary, and that voluntariness in matters where individuals been reported as having caused sexual harm is not voluntary as it may be in other senses, but it is at its best when folks want to be there, and the example we have demonstrates that. And so the conference process, once we arrive there, and it may take several meetings before folks are ready to be there, but the conference process, which could be folks in the same room together, physically, or the same Zoom room, or take place in sort of a caucus-based format, allows us to explore together what happened, what was the harm, and how can we prepare that to address the harm that was created. Optimally, if those sessions proceed as we typically hope they will, it will result in an outcome, a restorative agreement, a redress plan, repair plan. Schools have different ways of describing these. Regulations call them informal resolution agreements. Would result in an agreed upon set of restorative measures that the person who's caused harm would agree to complete as a way of addressing that harm. And then the institution, likely through the Title IX coordinator, has a role in monitoring that and assessing whether or not that person has completed it. But that work of sort of the pre-conferencing, conferencing, and post-conference process looks different depending on who the facilitator is. And so I know we want to talk a little bit about that too, Paige.
Absolutely. I know I want to make sure that we have time to get to questions. So I'm not going to go through all of this. I think Jay did a great job of hitting the pre-conference and the phases and the considerations hitting on. And this is for the lawyers who are general counsels or advising schools or individuals, maybe on the defense side, about whether to engage in a restorative justice resolution. So this message is for you. There's very few reported cases, right, where a person has litigated the enforceability or the application of a RJ informal resolution. Or informal resolution more broadly. We have some theories about why that happens, but because the process is so consensus-based, because it is taking into account the needs of everyone, because there's such a rigorous assessment for voluntariness, we tend to find that people are happier with the outcome than in a traditional investigative process when it's taken all the way through to fruition. And so we often get that question from general counsels of institutions, especially, what am I going to do if how am I going to avoid litigation or getting sued for this? The process itself is designed to mitigate that harm. And just want to hit again on that voluntary position. And I'm just going to skip ahead. Jay, do you want to lay out our story about Anwen and Samir? And spoiler, you guys, you can read about this story. We've put the link here on the Reckonings podcast. Highly recommend that you listen to it.
Yeah. So, part of the challenge of doing this work is that it often takes place in private, and we're not able to talk about it publicly. I like this particular example when we use it because it has been written about, it has been shared about in this podcast. And so when you're thinking about those cases we mentioned earlier, with the reminder that this is a broad spectrum of behavior, but those cases you might think, no way is a person going to agree to that. You might find yourself sort of on that non-consensual sexual contact realm with sort of a forcible nature. And this particular example, I think, is really powerful because it involves two students at a school in the Northwest who use the pseudonyms here as Anwen and Samir, who in which Anwen experienced a form of sexual assault or sexual violence, and that could have been dealt with through a traditional legal process. a traditional legal process or a traditional adversarial grievance process. And these parties took a very different approach for lots of different reasons. And so the podcast does a really nice job of sort of sharing the example, but beginning with the reality that this particular survivor didn't want a formal proceeding, and the recognition that the respondent was absolutely terrified, not only of the process, but what acknowledging his behavior meant about him, what that would do to his identity, what he might need to call himself for years to come. And so an informal process, an RJ process, allows us to detach those things, to detach our own worst behavior from our identity. And that is really important when we talk about sort of the process of accepting responsibility, particularly in those instances when denial it may be a sort of natural reaction in an adversarial process. So I know we want to leave time for questions as well. And so Paige, let's bump forward and you maybe help us think how we want to get caught up. The next couple slides are sort of about how we prepare. And this preparation phase is really critical, but it acknowledges that folks are often better equipped to participate in these processes when they're not doing it alone, and that support persons and advocates can be really helpful. And in the case of informal resolution, it might be helpful to have an advisor who fully understands what a restorative process is. We have the benefit of working with attorneys in these processes, some of whom have no awareness of what an RJ process is. And no way is my client going to admit to that in this process. It's like, okay, well, we're not understanding. We're on different pages about what this is and what's required. And so we are happy as facilitators and support providers to work with counsel to make sure that parties are given the space they need and want to engage in the way that they want. And when that desire includes accepting responsibility for behavior, we work to the best of our ability to create that space. And so having the right support folks really does make a big difference. As you're thinking about that, we also have to think about sort of the types of harm that get caused and what we need to address. And so suffice it to say that when we think about this, there are lots of ways that harm can be identified, from sort of emotional, physical, social, historical, relational, or communal. And an RJ process seeks to address and repair each of those harms to the greatest extent possible. And that is not always easy to do. If we bump forward, I can tell you that on in the instance of Anwin and Samir, what that meant for Anwin was for Samir to accept responsibility for the behavior, to acknowledge what went wrong. So often we hear from victims and survivors that what I really want is for them to acknowledge what happened, to say they did it, and for it to never happen again. And our adversarial processes, our traditional grievance processes, just aren't designed to make that happen. What they're designed to do is give parties the opportunity to dispute the facts in a sort of a adversarial grievance process. By eliminating the need for that, by creating a way in which a party can acknowledge the harm, we create a lot of space to explore harms, needs, and obligations. And in Anwin and Samir's case, that meant acknowledging that harm. Anwin had written quite extensively about the harm she experienced in her major and just the course of her work on campus. And for her, that meant having Samir read what she had written. It meant sitting and listening to her presentation and talk at a Take Back the Night event that was extremely uncomfortable for Samir. It also meant engaging in a process with Samir that required him to listen and really confront his behavior. It also meant, as a result, getting out and talking about his experience. And so one of the things that was really important for her is that just as it was important for her to be able to tell her story, she thought it was important for Samir to be able to tell his story in his own pace. And that story came in the form of recorded conversations that he had with Anwen, and what to me is still just a remarkably striking example of what's possible when we create space for parties to do what they felt need to be done. And this example is a note that Samir wrote and published in their student magazine, which not only walks through his behavior, but acknowledges it in very direct terms, in terms that are so direct that I think plenty of defense attorneys say, this will never happen. I would never advise my client to do this. No way, no way, no way, no way. And in this case, it was not only possible, but restorative and had the effect of helping resolve this matter and did not subject this particular person to additional civil or criminal responsibility. And I think this is worth sort of acknowledging these explicit terms. He did not notably use his pseudonym in this piece, and so it's redacted here. But my name is, I'm a senior, I'm from Los Angeles, California, born of Salvadoran mother and a Pakistani father. I have raped, I'm a rapist. That is mind-blowing for me when this happened. And I can tell you that Samir is not the only person to have accepted responsibility for behavior that was very hurtful to others. And our conversation today is really about how do we create more of these opportunities that allow victims and survivors to have their needs met, to not only get that acknowledgement but to have harm doers be able to stand up and say, I did it, and have that work be supported as well. So we could clearly talk for days about this and know that we have some questions we want to have time for too. So Paige, I'll turn it to you and then we can get to those.
Yeah, thanks so much. And want to emphasize, the Reckonings podcast is a great model. You should listen to it. And, sometimes survivors want that level and we're able to achieve that level of resolution. And other times the stakes, it can look very different. It can look like programming that the institution is involved in and community awareness events that are not necessarily written dialogues, right? And that the power and the potential of RJ is that it leans in to the educational mission of the institution. It speaks to restoration and rehabilitation, right? To give us the chance to humanize individuals who cause harm and, cede agency and autonomy to survivors, and to really create this opportunity for healing. And that's notably missing in our traditional legal proceedings. Avery is going to queue up some questions for us. I know a couple of you had them, and just as she's doing that, also want to flag, because we know of this particular audience, we always get the questions, well, what do we do about the fact that sexual assault specifically can reach the level of a criminal violation, and there might be concerns for participating in an informal resolution process and a restorative justice process because of that. So we've hit on a couple of them throughout our presentation, but I just wanted to bring that together for y'all now, which is, remember, Jay talked about, you may in your state or in your jurisdiction have a rule of evidence, right? A professional rule in the attorney context, a professional rule in the mediation context, or a evidentiary rule that can be in your rules of evidence or in state law that explicitly provide protection. This is happening in a lot of jurisdictions, a lot of great advocacy. So check your local rules and regulation. And we mentioned sort of contractually agreeing, right? We can get people to agree as a condition of participating in a process to have that confidentiality. And the last thing I'll just mention is it is an excellent practice. You are probably obligated under some state law. Many states have these requirements for schools to have a MOU with local law enforcement around how they are going to handle concurrent investigations. And so if you have, or even if you haven't, a best practice, as you're thinking about that relationship intentionally, adding in language so that there is a shared understanding between the institution and local law enforcement that we are not going to produce documents and communications as part of our restorative justice process if the worst happens and a case is prosecuted outside and after an RJ process. So just wanted to flag those. We know that those questions always come up. And hello, Avery, welcome back.
Hello, thank you both, Paige and Jay, so much for your time. I feel like this conversation could have gone on for, gosh, 2 more
Thanks.
hours, 90 more days, 90 more minutes, a few more days, couple weeks. No, thank you both, and I hope everyone that attended and listened in. Also, I know that I'm getting comments about how much they appreciated this information being brought today. So thank you again, both. Most of the questions that were asked through Q&A were mostly about nuts and bolts. And if you don't mind, at the end of this, as we wind down, would you mind throwing up your contact information? I believe there's a slide that has folks to be able to reach out to you if they have specific questions. The only questions I'm going to highlight right now as we wind down is really about Jay and Paige, your perspective. If you we're touching on the pros and cons and the benefits of RJ providers, but someone's really asking about having an external contractor versus an in-house person in these university processes, which would be preferred. And also there's some dialogue about having maybe a community representative element outside of support people in these spaces. What are your thoughts on those two specifically?
Great questions that we could unpack for a long time. I'm happy to take a stab, and I know Jay has insight. First of all, you have to, when I say you, schools have limited resources. And the great thing about restorative justice is, again, it's not a program, it's a philosophy, it's a way of approaching conflict resolution, is that lots of individuals can do this work, right? And so we always encourage folks to cultivate the competency and the capacity to facilitate restorative processes in-house, because it's a community held process and because we want ultimately more restorative communities and ecosystems. That being said, schools have finite resources and lots of responsibilities. And it can really help, particularly for matters of sexual misconduct and sexual assault and really serious harms. It can be extremely helpful to have an outside facilitator. And there's a whole host of ways there's a whole host of harms that you might want a restorative justice process for. So bringing in someone external who has a particular expertise, maybe a particular identity that the participants might connect with, or having a sort of a impartial or more multi-partial perspective that will help the community feel trust in a restorative process can always be an option. If you're interested in that, you can certainly reach out to Jay and to us at Clancy Street and to our partners at the University of San Diego Center for Restorative Justice. And Jay, I don't know what else you would add to that, or if you want to try to tackle that second question.
Yeah, no, I just echo what you said. I think we're always happy to have more work, and also always want to encourage internal capacity. And the only piece I might note is just that there can be some inherent conflicts of interest that we are always mindful of and want to make others aware of in the process too. That these parties are these processes are for the parties, not for an institution to expedite it. And certainly not, I think there's a question about this too that I can address, certainly not to cover up or hide unethical or inappropriate behavior in a way that is not reportable. Importantly, we should flag, we didn't mention this earlier, but the regulations do require, as a matter of record keeping, the 2024 regulations effective August 1st, as a matter of record keeping for institutions to track matters resolved through informal resolution processes. And I continue to think it is helpful and advisable for institutions to be as clear as possible about the number of matters resolved in those ways, sort of some non-personally identifiable details about the nature of the matters, to say this sort of matter resulted in this type of resolution agreement or mandatory outcome. To Scott's other question, Scott, thank you for all of them. it really is important to think about community representatives. So we didn't have it here, but our colleague Rachel King often brings us back to the restorative triangle that recognizes that there are really three primary parties involved in these matters. It's the respondent, the harm doer, the complainant, the person who's experienced harm, and the community. And that community voice is often represented in these processes by the Title IX coordinator, who authorizes or does not authorize it, and who may wish to retain some sort of veto power over the restorative agreement, and would ask to sort of approve the outcome. But it can be helpful to have a community representative in the space, in the process, that doesn't require the Title IX coordinator or the facilitator to bring voice to community concerns. That may be particularly true in matters where the behavior sort of rose up out of sort of a coercion supporting peer group, and was not enacted sort of in isolation. And that can be true in student groups, fraternities, frequently pointed to in that regard, that where we may have other work to do. And so I really appreciate that question, Scott, and think of it as a feature of the design process, and would call it situationally and case by case dependent on whether it would be helpful to have that person, and if so, who that person should be, because it may be that shouldn't always be the same person every time. But I really appreciate you bringing that into the room.
Yeah, and I'll just add just briefly to tack onto that some of the most powerful restorative justice processes that I've been involved in facilitating or just participating either as an advocate or supervising has been the cases where, kind of like what happened with Anwen and Samir, where there is a recognition of the harm caused by the individual person in the case of sexual assault, right, who engaged in the harmful behavior. But there's also an acknowledgement by others, including, right, the institution and the institutional representative in some cases, acknowledging that maybe there are conditions in the community that contributed to the context where the harm occurred. And so we see this often in the context of athletics, right? We see it in the context of Greek life and the complicated social dynamics of like having alcohol on campus or drug abuse, right? And an institution acknowledging that they could do more to provide structure, support, and accountability. And that really entering in as part of the conversation and final resolutions as well. And I've really seen that happen in really powerful, transformative ways. And it speaks again to the power of restorative justice as not just about the two individuals who are, of course, centered in the process, the main centering being for the victim, but the really positive outcomes that can come from the community and the broader dynamics and the spillover effects, not just in those two individuals' lives, but in the broader like cultural context of a institutional community. And so really, really powerful stuff. And we look forward to hearing your stories of success. Would love to hear your questions and challenges. So please reach out to us. And thank you again for the opportunity to share all of this.
And I see. Yes, thank you for the opportunity. And I just want to acknowledge too, we have a couple questions about slides. Yes, we were trying to move forward, and so did skip some. I can talk about it with Paige, but I think I'm comfortable sharing the slides if you want to email us afterward. I don't think Avery and Company typically make the slides available, just the recording, but please do email us, and be happy to get you a PDF version of the slides for future reference.
And just to flag really quickly, a couple more resources. I just wanted to flag the article, Restorative Justice Approaches to the Informal Resolution of Student Sexual Misconduct. I'm flagging that resource because if you go and get it, the appendices are both a model MOU for a local prosecutor's office for an institution who wants to implement restorative justice processes, and also a model informal resolution participation agreement Those are free resources in that article you can find online, written by David Karp and others. So just wanted to put that out there. And again, just tagging the Little Book of Restorative Justice series, which has great facilitation resources. If you're wondering, how do I learn how to do this? There's lots of great resources, but those books provide helpful guides, templates, and talking points for you to get started in that practitioner's journey.
Okay, thank you all. And I see folks sending us your emails. I will, Jay and Paige, with permission, we will send out a recording to all registrants. I will include your email addresses in that if you're okay, so folks can email you and request the slides and the name of the article again. That'd be great. Folks, thank you again for tuning in. I just want to remind you all, next month, we're going to continue down the legal framework path. August 28th, we have a collaboration with the American Bar Association on the Introduction to Restorative Justice Laws database. Folks will be introduced to the functionality of the database and how they use it to learn more about examples of restorative justice policy across the United States. So once again, we'll continue and round out the summer with these special issues. Thank you again. Don't forget to fill out the webinar feedback, and I'll see you next time. Thank you all.
Thanks, Avery.
Thanks.